Welcome back to the channel where I cover missing persons, unsolved cases, crime news, and more. Well, Tommy's case seems to be starting to inch to the Florida Supreme Court at this point. I did not do a video on when the judge actually denied the rehearing, but I did post on the community tab, and unfortunately, that was kind of expected. But his appeal has started to transmit to the Florida Supreme Court, and it looks like we've got some stuff happening on the Orange County Clerk's website in regards to transcripts filed and what have you. So let's jump over there and look through some of these documents to see where exactly Tommy's case stands as of right now. So this is obviously the clerk's website, Orange County, and you can see up here, maybe you can't see because it is kind of small, but 5/19 of 2026 there will be a hearing, and actually if you pull up this order here on the 28th, it gives the information on that. So it's a by Zoom, so I don't know if I can listen in. I'm gonna find out if that's something that is closed to the public or not. But again, this is the state of Florida versus William Thomas Zeigler Jr. And it's stating the order setting a hearing is the following persons are hereby notified that the Honorable Letitia Marquez has set a virtual status hearing for May 19th, 2026 at 1:30 p.m. at the Thomas S. Kirk Justice Center, Courtroom 3, 2000 East Michigan Street, Orlando, Florida, 32806. And all counsel shall appear virtually using the following link. And there's a link there, so I think I can go in and listen to it and take some notes. I don't think we're going to be able to stream it because you can't really stream that stuff without permission, but I would love to see what's going on, and I will let you guys know. I'm going to find out, though, for sure if I'll be able to get in there. But again, this was signed by the circuit court judge. So that's one thing. So that is what's coming up. And we've got transcripts filed here. And but there is a notice of cross appeal. So that's 4 pages. So let's go in here. I haven't gone through all these. The only one I went through was the information about the virtual court status hearing. That's the only one I really looked at to see where things were going. But again, this one here was e-filed last week as well. And the Circuit Court of the 9th Judicial Circuit in and for Orange County, Florida, State of Florida versus William Thomas Zeigler. Notice of cross appeal. Notice is given that the State of Florida, pursuant to Florida R. Appellate, I think it's Appellate, App P 9.140C1K, hereby files this notice of cross appeal to the Florida Supreme Court on the following orders. 1. The court's order regarding the release of evidence for DNA testing rendered on December 19th of 2022, and the court's supplemental order regarding the release of evidence for DNA testing rendered on May 19th, 2023. The nature of the orders are non-final orders authorizing the release of evidence for testing pursuant to a joint stipulation by the defendant and state attorney's office for the 9th Judicial Circuit over the objection of the Attorney General for the state of Florida. 2. The order granting evidentiary hearing on defendant's motion for post-conviction relief rendered on August 12, 2025. The nature of the order is a non-final order granting an evidentiary hearing on the claims raised in the defendant's motion to set aside convictions based on newly discovered evidence, which was filed on March 21, 2025. 3. The order denying state's motion to strike certain witnesses and exhibits and limit presentation of evidence rendered on October 10th, 2025. The nature of the order is a non-final order denying the state's request to strike witnesses or otherwise limit the presentation of evidence at the evidentiary hearing to the newly discovered evidence pertaining to the DNA results. 4. The order denying the state's motion for release of certain evidence for testing rendered on October 1st, 2025, and the order denying the state's motion for reconsideration of order on the release of certain evidence for testing rendered on October 9th, 2025. The nature of the orders are non-final orders denying the state's request to conduct additional testing of certain items of evidence. The defendant / appellate / cross appellees notice of appeal was filed on April 20th, 2026. So this is from the state, obviously, James Earthmeyer and Joshua Snow. So that is theirs. So let me find, because a lot has been posted in the last week on here. So here is the initial order denying the hearing. So here is the defense, and this is 49 pages. And as you can see, the appeal trial transcripts, there's a lot. And to read the 49 pages here is going to take quite some time, so I'm just going to kind of sift through just the start of it, and we may have to do a couple videos. Excuse me. I was watching a live stream before I recorded this, so a couple videos to go through it. But again, this is the actual appeal that the state is referencing that Tommy's team filed on April 20th. Again, State of Florida versus William Thomas Zeigler Jr. Notice of appeal, capital case. Now, for anyone that might be out there going, well, he's just lost his evidentiary hearing. The judge denied a retrial. This has been going on for forever. Well, that's just putting it mildly. Why does he keep trying? Well, guys, he's on death row. And, if you believe you're innocent, and, we all know how I believe Tommy, but I know some of you guys have questions still, and everyone's entitled to, obviously, to their opinion, and that's why we have juries and, all that in this country when we do these cases. But if you're on death row and you believe that you're innocent, you're not going to give up. You're not going to give up until, you've exhausted every possible thing that could either get you exonerated, have a new trial released, anything. So obviously the next step for Tommy's case is the Florida Supreme Court. Notice is given that defendant appellate William Thomas Zeigler Jr. appeals to the Supreme Court of Florida the order of this court rendered on March 6, 2026, and made final on April 17, 2026. The nature of the order is a final order denying defendant's motion to set aside convictions based on newly discovered evidence made pursuant to Florida Rule of Criminal Procedure 3.851, seeking to vacate and set aside the judgments of convictions and sentences of death imposed upon him by this court. This order was made final on April 17, 2026 by this court's denial of defendant's motion for rehearing made pursuant to the Florida Rule of Criminal Procedure 3.851 F7, dated April 20th, 2026, respectfully submitted, Ralph V. Hadley III. All right. And we have their certificate of service. Gotta get all the logistics out of the way. And here is, so they're attaching, I think he's just attaching everything in here. So let's just take a look. So this is the order denying defendant's motion for rehearing. Since I hadn't read it, I just posted on the community tab. So let's just go through it real quick. Order denying defendant's motion for rehearing. This matter came before the court on defendant's motion for rehearing filed on March 23rd, 2026. The state of Florida filed its response on March 31st, 2026. The court, having considered the motion and response and being otherwise duly advised in the premises, finds as follows. On March 6, 2026, this court entered its order denying defendants' post-conviction motion. The procedural history and case facts may be found in that order, and the court incorporates them by reference here. Defendant seeks rehearing of the denial, and such motions are governed by Florida Rule of Criminal Procedure 3.851F7. He alleges the court overlooked certain facts or law that he contends require that his motion for post-conviction relief be granted. He argues the court overlooked three main facts. 1. That multiple perpetrators committed the murders is supported by DNA evidence. 2. The defendant did not shoot himself. And 3. The court relied on facts not supported by the record. But this court previously considered each of the defendant's points raised in this motion. It did not overlook them, but found that the weight attributable to these points did not tip the scales to make it probable that defendant would be acquitted on retrial. While the court agrees that there are enough evidentiary issues in this case that a jury might acquit the defendant, there is also sufficient evidence and credibility issues to support a jury convicting the defendant, such as the court cannot conclude his acquittal is probable. In this court's opinion, he has not met the high standard necessary for a new trial to be granted. Accordingly, it is hereby ordered and adjudged that defendant's motion for rehearing, filed on March 23, 2026, is denied. Done and ordered in chambers at Orlando, Orange County, Florida, on the date of electronic signature, signed by Circuit Court Judge Letitia Marquez. I don't agree with her that there's not... Well, see, she says there is, but there's not. So it's such a weird denial to me. And yeah, I can see both sides of it, but it's still very strange. And, I still understand that Tommy screwed himself on trying to get someone to take the guilt for him earlier on, from someone in jail. I get that. Okay, guys, I get it. And Tommy has admitted that was really, really stupid. But that does not change the facts and what really happened on Christmas Eve of 1975. That doesn't change that at all. That he was also a victim, in my opinion. And the DNA evidence, shows that he was. And I think there's enough of that evidence to prove that there's just enough, that the jury would say, hey, he may be innocent. And that's all that the defense has wanted. That's all that Tommy and his team have been asking for. And it's like the state of Florida, Orange County, is just denying them at every single turn. And this has happened since this case just, came to fruition. So, that's not even counting all the corruption from 1976. So it is crazy to me that poor Tommy is still sitting, without any kind of, just paperwork upon paperwork, and everyone telling him, no, you did it. There's no possible way you didn't. So yeah, again, I don't agree with it, but So here is the order denying defendant's post-conviction motion. And again, these look like they're probably attached here. This matter came, let me just go through them real quick here. This matter came before the court on defendant William Thomas Zeigler Jr.'s motion to set aside convictions based on newly discovered evidence filed on March 21st, 2025. The state of Florida filed its answer to defendant's motion for post-conviction relief on July 14th, 2025. The court held a Huff hearing on August 7th, 2025. At the Huff hearing, Dennis H. Tracy III, Esquire, David R. Michelli, Esquire, Ralphie Hadley III, Esquire, and John H. Pope, Esquire, appeared on behalf of defendant. Defendant Zeigler chose to waive his presence. Jacqueline N. Brown, Esquire, Ralph V. Seagoben Jr., Esquire, and Patrick A. Bocock, Esquire, appeared on behalf of the state of Florida. John E. Snow, Esquire, appeared on behalf of the Attorney General's office. The court held an evidentiary hearing from December 1st, 2025 to December 5th, 2025. At the evidentiary hearing, attorneys Tracy, McKelly, Hadley, and Pope again appeared on behalf of defendant Zeigler. Mr. Zeigler was present. Attorneys Seagoben, Brown, and Bobek, I'm sorry, I'm butchering this poor guy's name. Bobek appeared And on behalf of the state of Florida, Attorney Snow appeared on behalf of the Attorney General's office. The court, having considered the motion, answer, and record, having considered the testimony and evidence presented, the argument of counsel, and being otherwise duly advised in the premise, finds as follows. And yeah, we went through all this stuff. So this is the judge's decision. So I think that it's going over how he was charged on March 26, 1976, and then on July 2nd, 1976, following the jury trial, the jury found Tommy guilty of first-degree murder of Eunice Zeigler and Charlie Mays, and second-degree murders of Virginia Edwards and Perry Edwards. And that the jury wanted him to get life in prison for all of this. The judge, that's even after the whole one juror was drugged, basically. I mean, because the judge called her doctor. I mean, can you imagine them doing that in this day and age? Oh, you mean you're having issues with, deciding on a case? Well, let's call your doctor and have them call you in some drugs so that you can properly consider that this man is guilty beyond a reasonable doubt. I mean, that is just so damn ridiculous. That's just not how our justice system works, people. And then and after all this, when this juror finally decides to say, okay, well, he's guilty, and we all know that she wasn't for it. She had a lot of questions. The judge said, you know what? We're not going to put him in prison for life. We're going to put him on death row, sentence him to death. So, I mean, we're just talking about so many problems, and that's why I think Tommy's case is just, he's had so much against him from the get-go. I mean, it's really sad. But yeah, we went through this in another video, so please check out the playlist, because I went through all of this stuff and with all the footnotes, because this was quite extensive. So let's see what else is in here, because this is the finding. Okay, so this is probably all the 40 pages here. So that's my guess, because if I am correct, her judgment was 44 or 45 pages. Let's take a look. Her decision. Where is it? I gotta find it. There it is. Okay. So here is hers. So that's what it is. That's why there's 49 pages, because of what we just read, and then the 44 pages would be the judge's decision post evidentiary hearing. So then we're talking about all the exhibits are posted here. And then Tommy's team, they obviously went up here and they did the motion for rehearing, which I covered and I did a video on. And then, of course, the state was like, no, we're not going to do that, and blah, blah, blah. And then the judge on the 17th of this month said, no, I'm not going to grant that. And then on April 20th is when Hadley and team for Tommy filed that they're going to do an appeal with the Florida Supreme Court. So let me pull this up here, because there's a mandatory review and all this attached here. Let's take a look. I know I'm kind of jumping around just a wee bit, so hopefully I don't get you guys too confused with my ADHD brain. So here's the Supreme Court of Florida. So remember, when I say Supreme Court going forward, I'm meaning Florida Supreme Court, because that's the next step. Once the county and district and all that's going to be your next step, is the Supreme Court of that state, and obviously this is Florida. Acknowledgement of new case, Wednesday, April 22nd, 2026, regarding William Thomas Zeigler Jr., appellate and state of Florida, appellees, and then there's the case number and lower tribunal case number, and it says case type, mandatory review, death penalty appeal, and then we have our statute here, the 3.851 successor. I think I know that statute really, really well now. The Florida Supreme Court has reviewed the notice of appeal reflecting a file date of April 22nd, 2026. Please be sure to register your appellate case information system account. So I think this is all going to jump to another website, so I will look into that too. So here, and then there's another document here from the Supreme Court. I don't know if this is just an. It actually looks like. Let's see. We have received a notice of appeal 3.851 successor in the above captioned case, which is an appeal from a first degree murder conviction with a sentence of death. Pursuant to Florida Rule of Appellate Procedure 9.142A1, the Honorable Lisa T. Munyon, Chief Judge of the Ninth Judicial Circuit of Florida, is hereby appointed to monitor the preparation, if I can speak properly, of the complete record in the circuit court for timely transmittal to this court. The transcript should be filed with the trial court clerk within 50 days from the filing of this notice of appeal in this court. As the time for filing the transcript has already been extended, the court does not anticipate that any further extensions of time will be necessary. The trial court clerk shall have 20 days after the filing of the transcript with which to transmit the record on appeal to this court. The complete record in a death penalty appeal shall include all items required by Rule 9.200 and by any order issued by the Supreme Court. In any appeal following the initial direct appeal, the record transmitted shall begin with the most recent mandate issued by the Supreme Court or the most recent filing not already transmitted in a prior record in the event the preceding appeal was disposed of without a mandate, and shall exclude any materials already transmitted to the Supreme Court as the record in any prior appeal. The Supreme Court shall take judicial notice of the appellate records in all prior appeals and writ proceedings involving a challenge to the same judgment of conviction and sentence of death. Appellate records subject to judicial notice under this subdivision shall not be duplicated in the record transmitted for the appeal under review. Pursuant to Florida Rule of Judicial Administration 2.215I, the circuit judge assigned to the case shall take such action as may be necessary to ensure that a complete record on appeal is properly prepared and transmitted. The Honorable Letitia J. Marquise is directed to hold a status conference within 30 days from the date of this order, which shall be attended by the clerk of court or the clerk's designee, all appropriate court reporters, counsel, and such other persons Judge Marquise may deem necessary. Judge Marquise may enter such orders as necessary for the timely completion and transmittal of the record on appeal with this court. The time and place of the status conference shall be set by Judge Marquise for the purpose of ensuring that the record on appeal is complete. Judge Marquise shall file with this court within 20 days from the date of the status conference a report detailing the current status of the record preparation if the record has not yet been transmitted. The record on appeal shall be timely transmitted to this court unless there are substantial reasons requiring delay. The trial court is reminded that only this court can extend the deadline for transmitting the record on appeal. Pursuant to Florida Rule of Appellate Procedure 9.200E, the burden to ensure that the record on appeal is prepared and transmitted in accordance with the Florida Rules of Appellate Procedure shall be on the appellant. Counsel for the appellate is hereby directed to file status reports with this court every 20 days regarding the progress of the completion of the record on appeal. The failure to timely transmit a record on appeal substantially affects the court's ability to timely process its death cases and will not be tolerated. And that's in bold and underlined. A true copy test, and it looks like it's signed by John A. Tomasino, clerk of the Supreme Court. All right. So this is explaining why we have a status hearing coming up. Yeah. So there we go. So that's pretty much where things are right now. So I don't know if much is going to happen besides getting all these documents over you guys, but yeah, that's where Tommy's case sits as we speak today. That's where things are right now as of April 29th, 2026. So what do you guys think? I mean, do you think that we're going to get something different from a Supreme Court? I know I'm hopeful, and I know I'm stuttering when I say that, but I am hopeful for Tommy. I truly, truly am. I just feel like he's just got so much against him, and I don't know. I just feel like the guy deserves a break, but I mean, I just feel like the system hasn't been fair to Tommy, but I guess we'll see what happens. I will keep you guys apprised as to anything else popping up. It looks like they've got a lot of the documents already uploaded, so I think that they might be pretty much ready already for the status conference next month. But I'll keep an eye on it, and then I'll let you guys know what does happen at the status conference. And like I said, I think we're going to end up jumping to another clerk's site. My assumption is we're going to be on a Supreme Court website because it mentioned that. So I'm not as familiar with the Supreme Court cases. I'm usually following all these from the county. So I'm going to find out about how to continue to follow it on that. But with that said, that's all I've got for today. And please, as always, let me know your thoughts in the comments. And I know a couple of you guys, have brought up a lot of good comments, whether or not you're on Tommy's side. And that's totally fine, because everyone's been very respectful. So I do appreciate that. All right, guys, I hope you have a great rest of the day. And most of all, stay safe.